sentencing guidelines and the advisory range within this guideline manual. So this is a complicated part of sentencing. I think a lot of lawyers don't effectively communicate about this portion, which is the sentencing guideline manual right here, and the specific chart that places you into a specific category that is being recommended to the court. Now, there are ways to address the chart, and there are ways to address the advisory guideline range. There's a whole slew of legal strategies that are used in order to be able to get the court outside of that range. Specifically for us, what we try to do is obviously go below that range. So oftentimes what we talk about here is what's called variances and departures. And what we want to be able to do is highlight to the court, either through the notations that are made within a particular guideline or through statutory authority that's been created or prior case law in your specific type of case that has been addressed before, whether it's in this circuit or in another circuit or through the Supreme Court, that could help highlight that your case is appropriate to go outside of the advisory guideline range. For me, this is a really large portion of my federal practice. I think that I file objections in almost 90+% of cases that I have. And this is where you can get the most creative traction in order to be able to highlight certain aspects of how the advisory guideline range is not fair to your particular circumstances or to your case or the involvement that you had in your case, such as where you fall on the hierarchy of individuals and who did what, when, and how.